part of it. I've been practicing law now for just about 3 years with Maurice Law. And a little bit about Maurice Law. It was founded in 2002 by Ron Maurice after about a decade working in historic treaty breaches and specific claims at the Indian Claims Commission. And from then, the firm started building a track record and settling, litigating and settling treaty claims, right? Setting precedents that help not only Maurice Law clients, but everybody in Indian country. So it's actually, the first and only Indigenous-owned national law firm in Canada. So I'm really proud to be a part of the team there. Today we're a team of over 20 lawyers, and we are a specialized firm that practices almost exclusively Indigenous law and with a focus on treaty rights litigation. So, really honored to be a part of the team. Integral to our practice, like I said, is treaty rights litigation. So it took nearly 100 years after the treaties were signed until Indians were allowed to hire lawyers or become lawyers. And as a result of that, a lot of things that Canada did, wrong to our people in the late 1800s, the early 1900s, there was no way for us to hold Canada accountable for those wrongs. And that's because of something called a limitation period. In Canadian law, a limitation period is basically a time limit you have to advance a claim before the courts from when that wrong occurs, right? So
as I just pause for a minute here. Don't block the hip again.
Okay, so like I said, there's a large period of time between the signing of the treaties and before Indians were allowed to hire lawyers or become lawyers. And so a lot of these claims, by the time we could actually advance claims, they were defeated by the statutes of limitations, which are basically time limits you have to advance a claim. In most cases, it's about 2 years. So Canada's first, once Indians started becoming lawyers, and we had national advocacy groups, Canada founded something called the Indian Claims Commission in the late 80s, early 90s. And the Indian Claims Commission was the first attempt at a specialized court to deal with historical treaty breaches. Now, it was the first court of its kind. It wasn't really a court, the Claims Commission, right? Basically, what the commission could do was hear submissions, legal submissions, and ultimately issue a recommendation to Canada as to whether or not to address a claim and how to do that. So they might recommend Canada pay money, but they couldn't actually force Canada to do anything. So a lot of claims that entered, that began in the Indian Claims Commission, they didn't really reach resolutions. And so this kind of changed for the better post-2008. In 2008, Canada passed what's called the Specific Claims Tribunal Act, which established the Specific Claims Tribunal. So the Specific Claims Tribunal was the beefier and better Indian Claims Commission. So the Specific Claims Tribunal has the power to issue judgments against Canada that are binding. They can actually force Canada to pay up to $150 million. And it prevents Canada from relying on limitation period defenses that they usually rely on when historic claims are brought before other courts, right? So the Specific Claims Tribunal, it was invented specifically to deal with these historic grievances, such as the topic of today's discussion. So I know it's kind of small here, but I'll walk through this little process map that's on the Specific Claims website. And it roughly sets out a timeline, how long it takes to advance a claim. Now, before you really even get to the first part of this claim process, it takes about a year to 2 years to research and draft a claim submission, right? So once that's done, you can submit your claim submission to the specific claims branch, at which point it undergoes the first step, which is the blue 6 months early review, the minimum standard review, as they call it. And in that initial period, the branch will examine the claim and make a determination as to whether it is, sets out a valid legal claim, right? And there's a valid historical basis, but it's only preliminary at that point. So once you get past that 6-month hurdle, then you enter the 3-year minimum review period, or the 3-year mandatory review period. And this is a longer, more intensive review period, which takes 3 years. Canada takes the full 3 years every time. At this point, the Department of Justice and the branch are reviewing the claim to reach a determination as to whether to offer to negotiate the claim, to accept it under the policy, or refuse to negotiate the claim. Now, at that point, we're into the process already. You have the option to, if Canada offers to negotiate, you can go into negotiations. If they refuse, then you can proceed to a tribunal. Now, there's some more nuance there. Sometimes Canada will give you a partial, acceptance. They'll offer to negotiate a part of your claim, at which point you still might want to go to tribunal. But once you get into this negotiation period, ideally in Canada's process map here, it should be resolved in about 3 years. Now, as Steve will talk about later, it's not always this clean, but this is the general idea about specific claims. So that's just a little background on specific claims in general. But let's talk about the history of cows and product claims. Now, I think most people here will be roughly familiar with the historical basis of the claim, right? Under Treaty 6, we've got the provision in Treaty 6 put up on the screen here. There was a promise by the Crown to provide a suite of agricultural implements and livestock, a one-time provision, to every treaty signatory band, right? So that's the root of it. But really, it starts before treaty, right? And you can see this is quite a lengthy provision, right? All the aforesaid articles are to be given once and for all for the encouragement of the practice of agriculture. But it really starts before treaty. From the time of contact to the time of treaty signing, some estimates are that about 50%, over 50% of the indigenous population in North America have been reduced by, diseases and other factors brought over by settlers, right? And leading up to the time of treaty, increased immigration into Turtle Island, into our lands. Further, more and more settlers coming west put pressure on our ways of living, right? It became harder and harder to live off the land. And one such way was the overhunting of the buffalo, right, to near extinction. It placed a lot of pressure on the ways that our people lived in those days. So, leading into treaty, our people were in a bad way, and the leadership of the day, our chiefs of the time, they saw the need for our people to adapt and participate into the larger agricultural economy that was really beginning to take off at the time. So Treaty 6 was first signed in 1876. Now, Thunderchild Band did not adhere to treaty until 3 years later in 1879, right? Once Thunderchild Band signed treaty, we were actually forced to move to Moosomin, where we stayed there on that reserve, farming with them until we eventually moved to our own reserve in '84. Now, the first time Thunderchild Reserve was set aside was '81, but actually the band didn't move there because it was small, for one, and it wasn't until '84 that they surveyed a reserve of the proper size for the population of the Thunderchild Band that we moved there. So in '84, we had some farming experience with Moosomin, and we began our own farming efforts in Thunderchild, but the progress was slow. Shortly after 1884, was the Northwest Rebellion, so-called Northwest Rebellion of 1885, and Thunderchild was, categorized as a rebel band. Now, there's no historical evidence that the Thunderchild band really had any major part in those events, but nonetheless, it was used by Canada as a justification to withhold annuities and other benefits under treaty. Now, in the larger picture as well, Canada was cutting funding to Indian Affairs, and so a lot of the benefits that were promised to our people never made it there, right? Any progress we made was really in spite of Canada failing to honor their treaty promise, right? So that's we got a slide up here, the legal basis of the claim. Canada failed to honor their promise, right? We did farm a little bit, but that was in spite of the lack of provision of those things that were promised under treaty, to our people collectively, for our nation. Not only did they, I'll pass it off here to Steve to talk about the legal battle, but just to put a button on it, Canada not only didn't provide the benefits they ought to have under treaty, but they actively undermined Indian farming across Indian country and for Thunderchild as well, with things like the pass system and the permit system. So that's the historical basis of the claim, guys. Now I'll pass it to Steve here, Steve Carey, to speak to the legal battle that it took to get here, and it wasn't simple. So thank you all.
Prior to Steve's I'd like to thank you for your historical presentation. Ed, can you please your three abilities again here with some historical?
Den askelman. Aivan kuin tämä on noja. Se on kannau, vakuuma kannau etukäteen. Vamskota mavumaa, että pamata on kattu nautis. Joka minä nau ei ole tohtee vaivaa. Espir. Kun tämä pamata on maailma uikin högspä. Tämä on maa, että voi teitä. Eikö teiskin aina ole kattonut minua? Mä oon moja upea vuoro kattoko. Mansko on real conflict. Moja on rebellion, kun tämä ei tämä tasata. Eikö ne mä son vanaa nohtaa ei tämä kotiin. Muin on ollut minä antau pitää, mä antau pitää. Taikonan, te olet tietysti nähty antoisi. Taas poikin on minä tämä. Flight, Union Jack. Ja koska mä rensavoikaa mun paitset ja pahtama. Se kisemään jo päivää. They rode by the reserve. They didn't bother Thunderchild. Waa pahtama on kota kakuuka. Näpä heissä on kaikista inua. Sitä hemmas kua. Ai sinua, että kivi tsekkoa. Eiki utuamma, vaan kohtatset. Cousins. Joka minne jeloskai, päiviin sekta lapsetut. Ne tset, straight them on the back. Piisam sekin maailma unto. Kinstotamak. We swim, respect and stay down now. Askina ja kaikki jalat, kuiskäspäin. Mä moni on pitos sitä vastamaan ja meoge on. Mä tjuhit ne hela. Kiivetä ei skoa eikä tausta. Eikä tauka yrittää atsemoteva. Se on armoa lawyer. 1908 surrender makauja atsemotsekin. Ei koe, kiasken kauja. Ja kun ne tee karpiaan, niin totta avaan tänne oma vakotoon. Ajakau viikemään. Moja kun tämä. Epsasige mamma. Kinstagi teo aga kawi joalani. Matrimonial la kong kaitwe. Moja pek kiga sakatso kwasomse. Tapos na pero di paksay mahagan to. Ni pausta na agete ko. Kamachit. Kasama to tayo sinin. Maga munya petao uya suona. Uya wawe sin stokake. Pitos na kisto na to suwe pingano. Ay waota. Kape tamago ek sumagi sa toya pitaw. Ek so honano. Magam kao tokenena na makaske to big stone. Giwi tena was taxi. Where's Wawa Eleanor Thunderchild got the big script? No, you must have listened to your mushroom. Eleanor, I said, when we were making legislation, many of these people weren't even gun members yet. I said, that's when we found you in Mervyn. I wasn't lost, he said, I got in touch with my mushroom. You see, because of matrimonial stuff, a lot of lawyers came out from there. Big old jobs go with Trish Montour Gisigaso. Everyone got you built an outscore a big screen. Come yes, worried. There go one thing big way he thinks what that Trish. Don't come up. That will win. Say that. That will win. The truth. And that's what these guys are telling us. Sure, things are changing, but it's a changing world. Therefore, we have a lot of views, which is Mananto. It says negocia. Manto accelerates, he lets us decide on our own what we want to do. But I'm not going to speak for you. You decide for yourself what you want to do and think. It's none of my business what you say and think. Examma. Menascoma.
Thank you, Harrison. Will our presenter?
Thank you very much. And thank you everybody for having us out tonight. My name is Steve Carey, as Logan mentioned. We are colleagues at Maurice Lawn, along with my friend Blair Mahan and Jake Coper. So we act as legal counsel for the nation on your council file. So Logan did an able job of walking through the historical basis of the claim and sort of explaining what the whole thing's about. And really, when you boil it down, it's fairly straightforward. Canada had an obligation to provide 1,000 plows to your nation to facilitate the transition to an agricultural economy. They did not provide those implements, and that's what the claim is about. So this claim was originally filed in 2013, but you originally retained legal counsel actually 4 years before that in 2009. As we'll talk about as I go through my presentation, you know, Thunderchild's claim is part of a much larger fabric in terms of what the Specific Claims Tribunal and the Specific Claims Policy and process have been working to resolve for a fairly long time. So your claim was originally actually filed in federal court. Now, there are disadvantages to try to pursue a claim in federal court. Things like limitation periods that Logan mentioned. Things like prohibitions against certain types of evidence. Make it very, very challenging for nations to advance claims through that process. So that was really what led to the development of what's called the Specific Claims Tribunal. Now, when the claim was originally filed in 2013, it didn't really move at all. There was very little that actually happened on the claim. So we were ultimately retained in 2019, the end of the year, with one very, very simple instruction from counsel, which was to resolve this claim. And we had worked for Thunderchild in the past on the salaries claim, on the treaty of duties claim. So, you know, it's our pleasure to be able to act for the nation in advancing this. And originally the claim was filed very shortly thereafter after we got hired. And then it went into Canada's review period for 3 years. And what Canada's doing in theory in that review period is carefully looking at all the details and carefully assessing the claim to decide whether or not they feel like they're guilty of the crime you've accused them of, right? So it's not an unbiased process. You've got the government of Canada, who's the defendant in the lawsuit, who gets the first crack at deciding whether or not they're guilty. So that all culminates this year when that 3-year period had run its course and Canada offered to negotiate. But what I think it's important to kind of review and important to go through today is how this claim fits into the larger picture. Because, and I'm sure everybody's aware of this, there's a number of Treaty 6 nations advancing these claims, Treaty 4, Treaty 5, Treaty 10. And they're all really building on what were the first round of claims that were ever settled in relation to Council Laos, which came from Treaty 8, so just north of Treaty 6 territory here. And the Treaty 8 claims are important to sort of show how we got to where we are today, where Canada has offered to settle your claim for $155.4 billion. The first Council Laos claims that ever really proceeded were filed in Treaty 8. It was originally 5 different nations who filed claims. And in those claims, they were filed back in 1993. Developed in 92, so filed sort of towards the end of 1992 to then 1993. At that time, the process was very different. There was no 3-year period for Canada to review. There was no time limit at all. It used to take them on average 13 years to respond to any claim submission that was filed. Now at that time, as Logan mentioned, the only other option, unless you wanted to go to the courts, was to go to what's called the Indian Claims Commission, but that was a non-binding body. They could only make recommendations against Canada. So even if they lost at the Indian Claims Commission, you still didn't have to do anything. So when those first Treaty 8 claims were filed, they received no response. And in 1996, the matter was referred to the Indian Claims Commission by those nations. Now, the big question that was before the commission was whether or not they could even hear the claim. And what the question related to is that Canada hadn't rejected it yet. They simply did nothing, and they didn't provide any response. So the Claims Commission agreed to assess whether they could actually review the claim and came down to a hearing. And literally the day before the hearing was when Canada contacted those nations to say, whoa. Let's sit down and chat about this. Let's actually negotiate. And what you're going to see is over the course of the next 25 years, and that's what it always takes for Canada to do anything in relation to these claims. It always takes them the threat of an actual legal consequence before they do anything. So the parties started negotiating those claims around 98, 99, and each one of the 5 nations in those claims had a separate expert to try to deal with the question of, well, how do we provide compensation for Canada's failure to provide cows and pump? There had never been a cows and plows claim before, so there wasn't really a roadmap. We had land claims. There's been many of those that have been settled at that time. But land claims are very different, right? When you're talking about compensation and land claims, there are some established principles. Current unapproved market value is one of them, replacement value of land. Loss of use. That doesn't really apply very squarely when you're talking about implements and the treaty promise, right? You could look at the value of the basket of goods. You could look at however many cows, plows, scythes, axes, whetstones were supposed to be provided and use compounding interest. But that comes to, even in today's dollars, like $8 million. It's a fairly small compensation target, and it doesn't represent at all the damages that were suffered by Thunderchild, what were suffered by your nation, and every other Treaty 6, well, every other treaty nation through all the number of treaties. All the number of treaties have a variation except for Treaty 9 on the cows and plows clause. But the damages that were suffered were tremendous. So a lot of the old approaches to determining compensation didn't fit very well. So each one of those 5 nations hired their own agricultural economists. Each one of those agricultural economists produced a report. They're all different. The numbers are pretty consistent, but the methodologies, the way that they got to those numbers, were very different amongst the reports. Then Canada hired their own expert, a company called Sericon, based out of Edmonton here. And the Sericon report produced a vastly different result. So if you took the average of sort of the 5 First Nations experts, they're all fairly consistent, as I said. Sericon was almost 90% away from that. Same credential, different methodology, but now you've got 6 different methodologies, and the negotiations weren't really proceeding very far. Ultimately, everything broke down. And this would have taken it to like 2004-ish, 2005. And the parties had reached a stalemate. There was just, how are you going to bridge that 90% gap? Now ultimately, what ended up happening was the minister, and at that time it was Chuck Strahl, who intervened on the request of the nations after allegations that Canada had been engaging in bad faith. And what the minister and those nations agreed to was they were all going to agree on an independent third party. Turned out to be a guy named Bob Thompson, who works just north of Calgary. And what the parties agreed to was Bob's going to look at all these 6 reports. He's going to come up with what he thinks is the right model to settle, and we'll all be bound by whatever this guy decides. Now, ultimately, what ends up happening, though, is Bob comes back, does his report. A couple of years go by. He finally presents his findings. The nations immediately submit, their proposals to settle to Canada based on Bob's report as agreed, and Canada walks away from the table. So at this stage, about 2007, 2008, Canada had fully reneged on their commitment. They took negotiators off the file, they stopped answering the phone, and frankly, the negotiation was done. So this created a big problem because the only option for those nations, really at that time, was to file with the federal court. But for the reasons that I've already mentioned, and Logan walked through, the federal court's not a very reasonable venue to advance these claims. It's very, very challenging, and the DAC is set very much in Canada's favor. So when the claims were sitting in this process, it also coincided in 2011 with the opening of the Specific Claims Tribunal. And that became a fairly important new development in Canadian law. And for the first time, really gave First Nations a much fairer playing field when advancing claims based on breach of treaty. Things like limitation periods don't apply. They can't be used by Canada as technical defenses in the tribunal. There's no prohibitions on evidence like you find in federal court. But it had never, even though it was created in 2008, it didn't accept any claims until June 2011. So we had the good fortune of acting on one of those Treaty 8 claims at that time. And after having given Canada every single opportunity to come back to the table and to come correct, we were forced, essentially, after hearing nothing back from Canada at all, to file that claim to the tribunal. And this is all public, so I'm not able to talk about it, but this is on behalf of Mikisew Cree First Nation of the Treaty 8 territory. So we filed the claim to the tribunal. We had the chairperson of the tribunal, who was a federal court judge, a federally appointed judge, a guy named Harry Slade, who presided over the case. And Canada denied liability altogether. So after having negotiated for 15, 16 years at this point? A little longer than that? Canada took a new position when they were confronted with the tribunal proceeding and said that they had no obligation to provide any counts or any class at any time. Full stop. The land quality, they argued, wasn't good enough up in Treaty 8, so they had no obligation to live up to their treaty promise. Of course, that's a pretty cynical way to put it, right? Canada has no capacity to say that they made a promise that's a meaningless promise. That fundamentally undercuts the entire point of treaty. But that's what they presented as their case to the judge. So what ended up happening was Canada brought a series of motions. There were technical arguments, little nitpicky stuff, but each one of them we had to have a full hearing and prepare for a few months. Canada lost every single one of those motions, but in my view, and it's just my personal opinion, they never intended to win. What they were trying to do was to use their immense resources to simply overwhelm the nation advancing the claims. Just get it stuck in the process, delay it as long as possible, cost as much time, cost as much money, cost as much fuss as they could, to just push it off. And ultimately, they lost every single one of those. We argued our final hearing, which is probably the last one we would have had, final application, which is probably the last one we would have had before the actual final hearing, right? Like where you actually go in front of a judge and make legal arguments based on the substance of the claim. Everything up to that point had all been technical. Were documents amended at the right time? Is certain evidence allowed? The judge never had the opportunity to actually get to the substance of the claim. And right while we were waiting for that decision on what I think would have been Canada's probably final application before the trial, we got a call. And this would have been in January 2016. And our client was invited up to Edmonton, and I've talked about these claims a lot, and I always thought it was on the Kingsway where this meeting happened. I'm wrong. It happened across the street, right across from that chopped steakhouse over there. I noticed that today, which is kind of interesting how this all comes back to the same spot. And at that meeting, that original group of 5 claimants at that one had grown to 18. So there were 18 chiefs and councils who were all invited. and Canada's negotiators wandered around that room and handed out 18 envelopes with offers. Now those offers were based on that Thompson number. But it was 8 years old at that point. It was from 2008. So what Canada was really doing at that time was saying, and they actually said it straight up, we made a mistake in walking away from the table. We would like a chance to negotiate again. There's no trust left in this relationship at this point, but they made some commitments to move fairly quickly towards resolution. So from that meeting, the one condition they had in order to proceed with negotiating settlements was that Mikisew I had to contact the judge and ask the tribunal not to release its decision. And if we did that, they were willing to sit down and talk turkey, so to speak, and talk about settling the claim. Now ultimately, that meeting, a year and a half later, led to the first, and at that time, the only county cloud offers, which were consistent among all Treaty 8 nations. Right? Each claim was settled in the same way. And it used that Thompson report. I mentioned before Bob Thompson, the guy who had developed that independent report. What he was looking at and what he developed was a compensation model that looked at what's called the modern equivalent value of the promise. So instead of just taking the cow to cloud and saying that was their work and bringing that forward with interest, what he looked at was, well, if the promise has never been fulfilled, what would it cost to fulfill that promise today? What would it cost, and at that time, 2008 or then later 2016 dollars, to provide the means to develop a farm and a farming economy? So what he was looking at wasn't just any farm. It was, it's not a corporate cannabis farm on the one side, it's not a potato garden. It was a farm that, in his view, and from the view of the nations who were at the negotiating table, captured the treaty promise, which was a farm that would produce a livelihood, a farm that would produce a moderate livelihood for the farmers there, something that would create sustainable intergenerational wealth. So, Canada updates their numbers. They make an offer in Treaty 8, which is the first of its kind. And today there's, last I checked, there's been 30, I think almost every Treaty 8 nation has settled their claim. 31, 32 in Canada's reporting Canada that were settled. Do you want to pause there? Yeah.
Yeah, okay, do a short overview of the treaty we made.
I got a mom's got I got to come out. Yes, well. Dan so many months if I go by a thousand. What's up? I got to go to the one. There was my gun. Transform every one. It got coming every one. It's in the world. Got to bring what you know at the moment. Moja pachino mosso, moja pachino. Iko cheka na maga. Anong sa maga Pakistan Pakistan. Moja na kota na kota na tanitege. Tamay gagi pe wani chege all these years success. Thompson naman ay mo ma. They want this keeps tamay goma. Yes na they want this chege. They want make a mark sami maga. I'm sorry. Nietzsche, well, there was going factors. Hamana, when it came down to Hamana, they said, I ought to get up, she said, I'll pay her down. Nista, now, Nyam Sapa, Kimaya, and no Chita to make one decision, 25 years, he said. A quarter of a century. Vamos. Nato tota na hiyo awat na chile. Ewa, ekwa chimno. Hoy na nauma yagation out. They asked me who I was. Dati ho, Chief Thunderchild, no mas home. Nagtawag ko pigi, but they want to ask you a big strong water. Ni squad chama. Thunderchild family na peo. I'm the only one. Kakyo. Copy got the Guahos now. Every single one. More ways than one. That what? I think you said that's kind. I worked for the Federation of Saskatchewan Sovereign Indians. I was a government specialist for 4 chiefs. I was an EA for 3 chiefs. Government specialist, that's only Sacramento. I was the only one in Canada designated to develop government working structures as they worked with provincial and federal governments, and that was under the leadership of Perry Bellegarde. I worked with David Hennique, Saul Sanderson, George Manuel, all the greats. And everything that I know up here in the Hill they give big squash stick. Muy bad. They didn't teach slowly. The way we're learning today, it's very, very, very cool. I can't say anything. Cosa big squatta, che non mi da tapo ne apatitati. Maka overview ma tepi om se wasam se. And you data. Queso ma tapata tanto di base mai pa e goya. Daga tane ko mota ga tapsimia tane ko skai mbata. Tane ma ko mai mbata totama. Moya. Kasponse. It's not a me day. Think about the band. Kita sini no ko awasa. Eko chamo tagapia. Muy semak. Muy kakyo no, it's not possible. Mito tan oro into itakmako maha. Tagamina. Ogama aro. Giwi tamaman anak. Pakanang poko. Kakaskip. Ego mo tanga sa mga yo sa kanang spotama. Can I say this on a personal note? Pung noten tok. Kakyo tao ya nagageste, kakyo gito. Pero nito kantong pahas. Pero nito kantong takamat kito isino ay momacha. It's the same as killing a person when you gossip and talk about them. Not because speaks good time, let's do it right. Let's say something tamata. Hi.
Yeah. And thank you, Harrison, for your comment.
Thank you very much. So where we left it was the resolution of those Treaty 8 claims, and that's a very important time. And the reason it's so important for the claim we're here to talk about today was it also coincided with the very first Treaty 6 claim being accepted for negotiation by Canada. Now, that first Treaty 6 claim, I had the good fortune of being legal counsel on that matter as well, and that was brought by the Red Pheasant Cree Nation. So this was the first time, and it's not a coincidence that it came after the Treaty 8 claims got settled. It's the first time that Canada had ever accepted a Treaty 6 Council Promise claim. And it started off rough. Our very first meeting, Canada's position, we were pretty confident walking into this because we had just, after 25 years nearly, settled the first Treaty 8 claims. It seemed like there was a fairly clear path ahead. But Canada took the position at that first meeting and for the first while that Treaty 6 is completely different than Treaty 8. You can't learn a single thing from that process, those settlements, in relation to Treaty 6 because it's a completely different treaty promise, which is ridiculous. It's not. The amount of counts, the amount of times are different, but the purpose of the promise, to provide the means to transition to an agricultural economy, is identical, all the way up from Treaty 1. So we eventually overcame that, and once we got over that hill and Canada agreed that we should, take some guidance from the process of the Treaty 8 claims, what we ended up doing was jointly retaining an expert, and we hired the same guy. We got Bob Thompson out of retirement to draft a new report that focused on Treaty 6 territory. What is the modern equivalent value of the promise? What would it cost in Treaty 6 territory to start a farm that would generate a livelihood? Bob did his report. We met every month along the way. And that would have been, negotiations began in March 2017, and we got Thompson's report, the draft report at least, on I think it was January 15, 2019. Now, none of his findings came as a surprise as we went through this to either party, Canada too. And because we had been anticipating it, we were able to turn around and offer to settle with Canada the next day. And we had a negotiation meeting the next day at Saskatoon. So we presented to Canada. The offer was open for 6 months. It contained a fairly healthy compromise in it on the First Nations part to just get the claim resolved. Canada read it and they said they're going to need a bit of time to consider. And that kicked off a very familiar saga. So Canada takes the settlement proposal in Thompson's report. They're apparently very interested in it, and lots of people were working on it. Then our next meeting the next month got canceled. Then after that, the next meeting they showed up and said, oh, we're working really hard, but we don't really have anything to tell you. Next meeting got canceled. All of a sudden, this very familiar pattern started to emerge again. And ultimately, before the offer formally expired in June 2019, I got a call from Canada's negotiator at that time saying that they weren't going to respond. Not they're going to make a counteroffer, not they disagree with our number, but their official legal position was no position at all. They were just going to let the offer expire. They weren't going to bother responding to it. So what they proposed instead, because our negotiations are pretty much done at that point, because what are we negotiating if Canada won't even answer when we're trying to make a settlement proposal? So what Canada proposed instead was to appoint a third party, a former Supreme Court judge, and to take our negotiation and make it a mediation. Mediation is just pretty much a negotiation with an independent party sitting in on it. I don't have any problem with mediation as an idea. It can be a helpful tool. But in this context, Canada wasn't willing to provide anything to provide security for the nation advancing the plan. Right? Like, what was the nation giving up by entering into a new process altogether? Well, they're giving up their chance to file the claim with the tribunal. So we proposed a series of compromises, something that would give the process a little bit of certainty for those nations who were giving something up fairly substantially in terms of time. And Canada refused. So ultimately we filed the claim with the tribunal on either December 2nd or December 6th, 2019. We terminated negotiations and filed with the tribunal. So this kicks off what was a very intense, fairly brief, about 2 years, but a fairly intense legal dispute. Second time now, 1,000+ claims are at the tribunal. Different judge, decade later, but same old story. Canada, when we filed the claim, filed an application before they even responded. They filed an application to say the claim couldn't be filed with the tribunal. Their rationale, or their legal argument, if you can call it that, was that they hadn't consented for us to terminate negotiations. Now that's not how I read the Specific Claims Tribunal Act, but we still had to have a hearing about it. So again, these familiar patterns started emerging. Canada lost. So then we changed documents to do other things to do in a lawsuit. And Canada then brought another motion. They wanted to split the claim in two. Which in fairness, many claims to the tribunal, all of them until that time, really, starting with the WRD's claim that Thunderchild was an intervener on in 2011. But we didn't want to split the claim in two. There was no reason to deal with the issue of is Canada guilty, have a hearing, have a trial, have everything, wait for the judge to write a decision, then come back and do it all over again. We already had our case prepared. So Canada brought that application to try to split the claim into two phases. One about is Canada guilty, the other one about how much do they owe if we were successful in the first one. We also sought to introduce that Thompson report because we'd spent a fairly substantial amount of money and a lot of time in getting that prepared. You know, that report that was prepared during those negotiations, Canada never even responded to our offer based on that. Canada then sought to have that suppressed, so we had to apply to do that. So now we're on to 3 applications, and these were ultimately heard by the judge in November 2021, and a decision was issued shortly after that, and Canada lost again on everything. The report was in, it formed part of the evidence in the claim. The claim would not be split into 2 phases, and we booked a trial date, which would have been for early 2023. So ultimately what ends up happening, again, the history repeating itself, now that Canada has nothing standing between it and an actual day in court in front of an independent third party who's going to order them to pay money, they all of a sudden want us to negotiate. So I got a call from Canada's negotiation team, and usually Canada will not negotiate with you if you're suing them at the same time. It's not the law, but that's their policy. No litigation and negotiation can happen at the same time, which is another way they use that system to disadvantage First Nations. If I slipped in front of Logan's house and sued him because I broke my hip, we would negotiate right up to the day in court. Most claims never make it to court, right? Most lawsuits never actually find their way in front of a judge because the parties negotiate a solution before the trial comes. Canada takes the position that if you want to file a claim against them at the tribunal, tough luck. We're not going to negotiate with you. It's another way that they use that system to try to prevent nations from actually resolving claims. But in this case, when they faced a real consequence, and there was a real chance that they were about to really lose, all of a sudden they were super interested in negotiating. They didn't care about their policy. So we negotiated with Canada. At that point, the negotiation I think lasted 15 minutes. Because we already had all this work done. We've done it 2 years ago. We've done it before we filed the lawsuit. We did it with them. And that created enough certainty on the First Nation side to pause the lawsuit and to pursue a negotiated settlement. So this would have brought us into end of 2022. And that's the first Treaty 6 claim, that's when the first offer was made. It was made for a pheasant at that time. Now, the basis of the offer is consistent across all cattle classes. That modern equivalent value approach. Right? Bob Thompson did the Treaty 8 study that settled 30 plus claims now. He also did the study that underlies the Treaty 6 claims as well. So when we resolved, or when Canada finally offered to resolve Red Pheasant's claim, they also advised us at that time that this was likely the basis that they would seek to resolve other Treaty 6 claims. So that brings us into early 2023. And this is right when Thunderchild's claim had passed through that 3-year window, when Canada finally had legally the obligation to provide with a response. And they did. They offered to negotiate. Now, wandering into that negotiation meeting, we had spoken with Canada in advance, and Chief and Counsel all went down to Ottawa, met with the Director General of Specific Claims at that time, and we had told them in advance, we are all very familiar with the basis of the claim. We all are very familiar with the basis of the compensation law. Usually when you start a negotiation, your whole first meeting is just talking about the next meetings you're going to have. Right? You make like a yearly schedule for all the times you're going to sit down. That made no sense in this context, and then to their credit, Canada showed up with a number. Now the big questions we had were, well, what's that number going to be? Again, the claims are all consistent, but Canada took the position that any claim over $150 million, which is where the cap is for specific claims at the tribunal, they were going to seek to apply a discount. So really, the main questions that we needed to hear from Canada on at that first meeting were, how strict are they going to try to apply that? Because that's ridiculous, that your nation would be penalized because Canada took 140 years to resolve it. The fact that they get a discount over 150, I think is a ridiculous proposition. And to their credit, they abandoned it altogether when it came to Thunderchild. I don't know what they're doing with other nations, but here, for the offer they made to you, to your nation now, it's not adjusted. There's no discount on the 155.4. Ultimately, that was a fairly quick process to have that meeting, and then Canada said they were going to go and seek a formal mandate. So once you agree on a number, they still have to get the minister to sign off on it and to bring you a letter of offer. In the meantime, we started working on the settlement agreement, which is what's being voted on today. Now this, we'll walk through it now. But the process of actually negotiating the settlement agreement, which is usually very standard, was nothing remotely standard this time around. Canada sought to do a number of things in this agreement that are completely upside. They sought to remove clauses that have been there forever, general clauses like the non-derogation clause, which you'll see in the agreement. We'll talk quite a lot about it today. They sought to include provisions that would mean that this claim, by accepting this settlement, you'd actually compromise your other claim, which is completely offside. It's a ridiculous proposition for them to do that. They breached the treaty. That's the foundation of the claim. They breached the treaty not just this way, though. They breached it in a lot of different ways. And your nation's entitled to pursue those claims, and you are pursuing those claims. Sorry, I think I lost my mic. Am I loud enough if I just talk like this?
Perfect.
Okay.
Yeah, maybe we can use this.
Oh, sure, you bet. That way I won't go hoarse. Forgot where I was at. Settlement agreement, negotiating. Oh yeah. So they sought to include all these provisions, and it turned out to be a fairly tense and fairly aggressive negotiation we had to go through with Canada, even while we're waiting for that formal letter of offer, which wasn't sent out until a couple months ago. So ultimately, I'll do it. Ultimately, what ends up happening then is that we concluded the negotiations about the settlement agreement, and that's now what the nation is being asked to vote on today. So the settlement agreement itself is, well, it is just what it sounds like. It's an agreement to settle a claim. Now, if you boil it all down to its key components, there's really two things going on here. One, Canada has to pay compensation if membership ratifies the agreement. And what does Canada get out of the deal is that you can't sue them again for the same claim. Same in any lawsuit, same in any claim.
Same claim.
Once you resolve this claim is done. What is the claim? The claim is damages from 1879, when Thunderchild adheres to Treaty 6, to the date of settlement. That's it. There's no forward-looking component to this claim. This is all past damages. You cannot sue Canada again, just so I'm very clear on that, for those damages arising from its failure to provide cows and plows from 1879 to the date of settlement. But what you can, and what you are doing, in every one of these instances, is suing Canada for a whole bunch of other breaches of treaty. Right? There's a number of other claims the nation is advancing. Those are not affected in any way by the cows and plows claims. So that's in a nutshell what the whole agreement is. But there's lots of provisions, lots of legalese in it, and lots of complicated legal language. So I'm going to hit on really the key provisions of the settlement agreement now. So Article 1 is the preamble, it's on the first page. I won't do every one, by the way, because a lot of them are kind of irrelevant and not all that interesting. I'm happy to answer questions about the whole agreement. The important part of the preamble is Clause E there. This is what's called a non-derogation clause. Now this is also in the body of the document as well. I think it's Article 14. So it's written just in black and white in its own part of the settlement agreement. Well, Clause E says, no, this agreement shall not be construed so as to abrogate, derogate, or otherwise alter in any way the existing Aboriginal and treaty rights of the First Nation as recognized and affirmed by Treaty 6 and Section 35 of the Constitution. Now, that shouldn't be groundbreaking stuff, right? Specific claims relating to damages your nation has suffered for Canada's failure to fulfill the treaty. You could not file a claim to change the treaty. Canada could not unilaterally change the treaty. You can't by agreement do that. But it's important that that's specifically written in the agreement. Just to be very, very clear what this isn't, and that is a claim that can alter your treaty rights in any way. Well, what isn't this? It's naturally set out in Article 2. What Article 2 does is it defines the claim. Article 2.1 and 2.2 are the important parts of Article 2, and as I'll talk about in a moment. The rest of it, frankly, doesn't need to be there. It is there because of a fairly tense negotiation with Canada, and the need to deal with some, frankly, I think there are fears about settling this claim. But it's not binding, frankly. The rest of the section, you're not providing Canada with a relief. Remember, the point of the agreement is compensation is provided to the nation. Canada, you can't sue them again for the same thing. That's what a release is. The rest of Article, so 2.3 to 2.8 are basically just discussions. I don't think they should be in the agreement. We negotiated fairly hard about that. They're there, but they're of no legal effect and consequence in Thunderchild. They don't change what's actually being settled, which is set out in Section 1 and 2.1 and 2.2. So 2.1 makes a reference to what's called equitable compensations. The reason why we use that language is due to the breach treaty. And if we were at the tribunal, that's what they would be providing. If we had to go fight it out, they'd be providing equitable compensation for the claim. It's a specialized set of rules in relation to specific claims. Section 2.2 expands on that a little bit. I think Section 2.2 is pretty clunky, to be honest with you. There's a lot of words, but basically what it is saying that it's defining the claim based on what was filed under the specific claim policy. So it looks at some of the evidence that was pled, some of the policies that Logan talked about before, and what it says is that insofar as any of those things relate to Canada's failure to provide cows and plow, it's all about Canada's failure to provide cows and plow, then that is included in the definition of the claim. So again, 2.1 and 2.2 is really the meat and potatoes of it. 2.3 through 2.8 is what I've got on my slide here. I'm calling it discussion pieces, which I think is a generous way to put it. It talks about things the parties may do in another negotiation, right? So for instance, it's 2.6 and 2.7 talk about things Canada may argue in a future negotiation. Article 2.8 talks about things Thunderchild might argue in the future negotiation. It doesn't matter. You can already do that, and Canada could already argue whatever the hell they want, or whatever the heck they want, pardon me, in another negotiation going forward. So when I say that they're not, when I say that they're not super relevant, that's what I'm getting at. You're not providing Canada relief in relation to anything in 2.3 through 2.7, or 2.8 rather. Article 3 is important because it is the compensation piece, right? This is what is on the table for the nation in resolving the claims. Canada's offered to pay you $155.4 million to resolve this claim. That's based on that modern equivalent value study done by Bob Thompson. It's consistent with all of the other Treaty 6 claims that will come. Treaty 4, Treaty 5, it's consistent with Treaty 8. It's the same approach. It's unique to Treaty 6 because the numbers are derived from a study done in Treaty 6 territory, but the basis of the settlement is the same. The modern equivalent value. Article 4 is the release clause. The release clause is what Canada gets. So Article 3 is compensation, what the nation would get if you ratify the agreement. Article 4 is what Canada gets. And it's a release. That release says that if the agreement is ratified and approved, as voted on by nation members, then Canada will pay compensation. You cannot sue them again for the same thing in the future. This will settle the claim once and for all. But it will settle just this claim once and for all. It doesn't affect any other claim that you are or will advance in the future against the government of Canada for other breaches of treaty. This is for compensation looking backwards from the date of settlement to 1879. What happens if somebody does sue Canada again for the same thing is what Article 5 talks about. It's called an indemnity clause. And these, I've never ever heard, and I've done, if they said 60, I overshot it. It's over 40 now, but I'm not quite at 60. I've done about 40 claims that I've had the pleasure to work on that have been settled or resolved by way of the courts. And what the indemnity clause is it says that if Canada is sued again for the same thing, they have to notify you, and they will give you a chance to participate in that lawsuit. You can choose to participate, or you can choose to do nothing, but if you choose to do nothing, Canada can still defend itself in court. In the event that all of those things happened, and Canada paid compensation to whatever group this would be advancing your claim that you've already settled, then they may come to Thunderchild for a contribution. Again, this is literally, as far as I understand it, never happened in relation to any specific claim. But it's a standard clause in any settlement agreement, indemnifying the party that's paying compensation. Article 7, ratification. It's the process that everybody's involved in now. Basically, once you reach the minimum threshold for voters, it's majority rules, right? Just like most elections. 50 plus 1 carries the day. Now, if the claim is, if the proposal to settle that Canada's made is ratified and approved, that's that. Canada will pay compensation, the agreement becomes effective. If it is voted down and rejected, well, what happens then? In the event the claim is voted down, you've got a couple options. One, you can go, I guess you could try to negotiate again, but Canada's not going to give you a different number in negotiation. It might be adjusted for the passage of time, but right now they're dealing with dozens and dozens of these claims, so it will probably take a little bit of time. Canada may come back at you with the same offer. I think that it's almost impossible that the basis of the offer would change through any further negotiation. In my legal opinion, it is impossible. So that leaves you with the tribunal as your other approach. You can file the claim with the specific claims tribunal and put it up there. Now, what that process would look like for timing, I mean, we've done all the work, so we could move fairly quickly, but Canada would still have an opportunity to mount its arguments to get their reports. Probably be about 18 months, I'd say best case, before we'd be in front of a judge arguing it, and then maybe another 6 to get a decision, which could then be appealed. So, if the claim is rejected, that's basically where things are at, right? You can negotiate further with Canada, or you can file with the tribunal and see what happens there. Neither will be quick. The tribunal is capped at 150, so it would definitely be less money, because they're not legally allowed to provide over $150 million. Article 11 is, you'd miss it if you're just looking through the document, but it's extremely important. Now, this claim is a collective claim, right? Only the nation of Thunderchild can advance this claim. Individuals couldn't file a council clause claim. At least not at the tribunal. You'd have no standing. I guess you could try it in court. But there is no individual entitlement. The entitlement was because Thunderchild adhered to Treaty 6. That entitlement, you saw the cows and plows clause at the beginning. It's not things that are given out on an individual basis either. What the package of goods, the number of cows, plows, scythes, whetstones, depends on different metrics, right? So some are for every family, some are for every 3 families, other are for the chief on behalf of the band. There's a whole complicated formula in there. But what that reflects, though, is that it is a collective right. All treaty rights are presumptively collective rights, even though individuals exercise those rights. Just like hunting, right? It's a collective right. It's an inherent right. It's an aboriginal right. But still exercised by individuals. But it's a collective claim, this claim, just like all specific claims are. Just like that annuities claim from a few years ago. For individuals who had their money withheld, and Canada tried to argue at the tribunal that we couldn't even advance the claim because it was an individual claim. Now, they lost on that, but it's because it is a collective claim. It's collective rights. It's a collective treaty right. So, that's a long way of me getting to what the article actually said. This is the only guidance in the settlement agreement about how to deal with the compensation, and it's called a representation of warranty. There's a bunch of them in there. It's actually not 11.1c, it's 11.1a, and I forgot to change that. What it says is that the First Nation represents and warrants. What that means is that you're making a legally enforceable promise or representation that intends to use the compensation balance for the long-term investment and sustainable benefit of the First Nation, and shall take such actions as it deems necessary or advisable to give effect to that intent. What this means in practice is pretty much the only guidance from the settlement agreement about how to deal with the issue of compensation. Now, the only thing I think, from a legal perspective, that this would disrupt or that would challenge this, because it's pretty open, right? You can do whatever you need to do that is necessary and advisable for the long-term investment and sustainable benefit of the nation. The only thing in my view, that it prevents or would be a full PCD. And this we saw in Treaty 8. There were a couple occasions where nations paid out 100% of the money to the members that were alive today. Now, ultimately that's resulted in lawsuits, as I understand it, against everybody involved in that because of this law. What members from those nations have argued is that by paying it all out, that just deals with a snapshot of who's in the nation on that day, right? Your nation existed far before today. It existed far before the treaty. And it will exist forever, right? It's going to look very different in 100 years' time. Very few of us may be around, but the nation's still going to be around. So really, the way that this has been read and the way that, like the challenge when you're ever settling any claim or resolving any claim, is how do you calibrate the needs of individuals today with the needs of future generations? Just like the treaty right itself wasn't only intended to benefit the individuals who signed the treaty, it was intended to benefit future generations to come. The Council found the whole purpose of that promise was to provide a sustainable economic engine for the nation. So that's what Article 11 says, and that's how it relates to the question that people are being asked to answer. Article 13 is very important too. This is remember this agreement's binding on Canada too. And these are protections for the nation in my view. It's called Programs and Services. What it says is that by resolving this claim, your nation's going to receive a lot of compensation. Canada is not allowed to use any of that against you. Canada cannot say that we paid you a bunch of compensation, so you're not entitled to access to programs and services like you were before. Same for individuals. This ensures that the government of Canada cannot hold this out and use this as a way to try to reduce any access you have to any programs and services that are already provided by the government of Canada. From the perspective of those programs and services, it's like this didn't happen. Article 14, towards the end of the document, it's also on the first page, is that non-derogation clause again. Nothing in this agreement can affect, alter, abrogate, or derogate from any of the existing treaty rights of Thunderchild under Treaty 6, regardless of anything ever. It's a single clause, it's black and white. So it kind of ties it all together at the end of the day, and that's my presentation. But I'd be happy to answer any questions about the claim, about the history of the claim, about the settlement agreement. I'm all yours.
Thank you very much. Your presentation is much appreciated, and we'll entertain some questions here. The questions you ask, please make it to the point and don't ramble on, as I said earlier. And if your hand is up, I'll go to the microphone so you can ask any question. Over here.
Oh, in the back there.
Oh, at the back over here.
Thank you for that presentation. I have a couple of questions for you actually, and the first one I wanted to ask is, you talked about Article 5 in indemnity.
Yeah.
So you said that at one point there you said that Canada may seek a contribution.
Yeah.
Possibly, but to your knowledge, that's never happened. But can you please clarify on that and maybe give us a scenario?
Yeah, it's an excellent question. What I meant is I don't think any of the things that are contemplated by Article 5 is ever happened. It's not up? Okay. So what Article 5 looks at isn't, there's a specific set of things that happen in a row, right? If somebody later, let's say that there was a different group who sued the government of Canada claiming to be Thunderchild for the same claim that we're settling now, if that happened, Canada would notify you that they've been sued for this. Their legal position is going to be, we've already settled the claim, right? And they'll walk in with a settlement agreement to prove that. In the event that that happens and somebody else sues Canada for the same thing, they will notify you. And you have, and this is all set out throughout Article 5, you have the opportunity to participate in that lawsuit. You can also choose to do nothing. And what the rest of Article 5 says is, if you do nothing, and Canada were to pay money in relation to that lawsuit, then they could seek a contribution from Thunderchild. But what I'm not aware of is any instance where anybody's ever filed a second claim after it's already been resolved. So I've never heard of this actually happening in any way. But even then, you could participate in the lawsuit, and you wouldn't be subject to Canada seeking something from you at the end anyways. But I just never heard of it ever happening.
Okay, thank you. Now, are we going to be having a separate presentation on the legacy trust?
Yes, that's after me.
Okay. My question might flow into that, so I'm not sure. I'm wondering, during negotiations with the government or at any point in time, are there any stipulations that have said that where members of Chief and Council or people in negotiations have said that the people of Thunderchild weren't privy to any of this information, the negotiations?
I don't know if I understand the question, I'm sorry.
I would like to know if there were any stipulations, any clauses, or any oath of confidentialities that were signed stating that the members of Thunderchild First Nation weren't entitled to any information during negotiations. Meaning, were we, how do I say this? Were we not entitled to any of this information while the actual negotiations were taking place between Thunderchild and the government? Meaning grassroots people.
Yeah, and as I understand it, because I wrote a few of them, there were updates provided. In terms of the nuts and bolts, I mean, they're confidential negotiations. They're not confidential between the government of Canada and Thunderchild members, right? So the answer to your question is no.
Okay.
There was nothing in place for that. But just kind of to make it maybe a bit more general, when any claim is being settled, it can be challenging to make sure that all of the information gets out, right? And ultimately, at the end of the day, that's the intention behind meetings like this, is to provide that information and those opportunities to talk about what's being proposed.
So the people of Thunderchild, the members of the Thunderchild First Nation, non-elected members, we could have been a part of any meaningful consultation taking place then. We could have been, right, at any time? There was nothing saying that we were to be kept in the dark regarding this whole negotiation.
There's nothing in the negotiation protocol agreement or anything that says keep people in the dark, no.
Okay, thank you. One more thing, and this might, like I said, this might go into the Legacy Trust, I don't know, I'm not sure. Is there also, hello? Okay. Is there also anything else that stipulates that the amount of money that each band member receives, be it $15,000 or $25,000 or whatnot, is there anything in this agreement that says that each band member is entitled to this amount of money?
It's really only this
Set
clause.
amount of money?
It's really only this clause that provides that guidance, right? Which is that it has to be used for the long-term and sustainable benefit of the nation. Now, how each nation addresses that in each different claim is different, right? And that's the question that is really put to council when Canada starts to propose an offer is, what are you gonna do with it, right? And it's, I think, critical that members know the plan at that time when they're voting on it. If you were just to vote on the settlement agreement alone, then it's essentially, I guess you don't know what's gonna happen with it. So, you know, again, it's about, this is the only thing in the agreement, but what this means can change nation to nation. It's about what your financial partners have offered. Not everybody has the same strong relationships that Thunderchild does with your banking partners, right? So they may not be able to provide the same types of opportunities. So it really is just about calibrating the needs of today with future generations. This clause is what is that legally binding provision, but how that gets addressed is different for each nation and each claim.
Okay. So, just to reiterate what you said in that little section there, you said that it is critical for members to understand before voting. Is that what you said?
What I was saying was that it's important that there's a plan that's presented. If the plan is just you want to settle a claim and put the money in the general account, this is just my personal view. That would be very, very difficult to ask people to vote on something like that. So the usual practice is to make sure that there is a comprehensive plan in place that has future projections, that has all those details sorted out, or else these meetings would be very, very different. So that's what I was saying.
Okay. So, but yet at the same time, and then this question will flow into the next presentation, this trust that's being proposed to us here today, you said like a general account, but yet all of our monies are being flowed into this trust. And not just this cows and plows, but all of our accounts. And it says that in the first page here, page 14, in the third paragraph. So again, I think that this is probably maybe a question that will be clarified as this presentation moves on, but I think that's something that really sticks out in my mind. But thank you.
Thank you very much. Yeah, and maybe just to clarify the one thing, I was saying this is the alternative to just putting money in a general account, right? And using that as sort of a sub-in to say if there is no plan, that's just where things would go potentially. There's not a
We're going to wrap this up here very quick. Let me ask you a question to that member.
Here, Jerry.
Which I am entitled to ask you. If the no vote prevails, it'll be years away before this is on the table again, am I right?
What a no vote ensures is that this offer is off the table. What happens next? There's different possibilities, right? One could be you file a claim with the tribunal. Another could be you try to negotiate further. There's other sort of wild card stuff, like if there's a big change in government, that might have an impact on Canada's desire to negotiate at all. You don't know. But what Canada's offer is 155.4. That offer is being voted on. It can be approved or rejected. If it's rejected, we'll figure out next steps.
Okay, we're going to
so what you're talking about here is that no vote. I think don't confuse the people here in this place. The people are here with that no vote, that no, what the chief and council are up to. That's what that's all about. But you do the yes vote on to get the money, you know, so we can all divide it up the way it should be divided up, you know. So don't confuse the people with a no vote and when the chief and council want a yes vote for whatever they're trying to do to us as Thunderchild band members, you know, don't confuse that with what's going on today. You know, so that's what I would like to say. Thanks.
Thank you.
Okay, at this time, time is of the essence, and yes, I see that hand. I see that hand, and we're going to continue on with the next presentation.
Why are you censoring my question?
Let him talk.
Let him talk. Why are you doing that? We have a right to talk.
Well, of course you do.
Let him talk.
It's not even 7 o'clock.
You're censoring.
He's a band member too, let him talk.
That's our right
This is
as
a
a
public
band
meeting.
member.
You call yourself a Thunderchild band member? Act like one.
Exactly.
Yeah, same thing with you, but I mean,
Yeah, all right.
don't be so disrespectful.
Okay.
Why do you do that?
Because you're disrespectful.
Okay, Corey, meet to the point. Hello?
I apologize for my last comment regarding your Springer show. I take it back. Just one question. Are we able to get a copy of your slideshow, and what is your email?
Yeah, you can absolutely have a copy of my slideshow. My email is just my name, Scary, SCAREY, @mauricelaw.com. Happy to send anything around. And just so folks know, there's nothing in here that isn't in your info packages, right? So this is my attempt to summarize it for the meeting, but I'm happy to share it with anybody who'd like to talk.
Hello? Yes.
Thank you for your time. My name is Aaron Zorthi. From what I understand, and I probably should have studied the info packet a heck of a lot better, but we haven't even got any money from the government yet.
Correct.
Correct. Okay, good. A no vote will tell the government, hey, we don't have an agreement, we're not gonna be able to get any, we're not gonna be able to settle right now, and the government could be, if they act like it's a yay, we don't have to give Thunderchild their money. Is that correct? So
I can't tell you what the government thinks. I'm pretty cynical after having done this for a decade and a half. I think they're happy to not settle anything ever, in my experience.
So I'm kind of on the right line, correct?
In my personal view, I can't speak for the government.
Thank you very much, yes, that's your view is what I'm going for. So, if we vote yes, we're not saying, yes, we agree to such and such amount of money being distributed to us. Or we
Incorrect.
are.
You are. Because the question has two dimensions to it. Do you agree to the settlement agreement and the trust agreement? It's one question. You can't
Perfect.
vote for one, not the other.
Okay, thank you.
And the trust agreement is what sets out that number.
All right. Ladies and gentlemen, I hope I am not hurting you and disappointing. I know it's disappointing what I'm about to say next, but I believe that a vote yes is in order. If we vote no, all those crazy claims that we thought were just, scary tactics, it's true. We're not going to get any money, and it's going to take another 10, 13 years for another specific claims court. I came into this with no knowledge. All I had was emotion and a bunch of information from a lot of emotional deliveries. I'm not calling the people emotional, I'm just saying that when I got this information, it was emotional. And it wasn't from who I'm looking at. It was from the people that stand behind me. Thank you for your time.
Thank you very much.
We have a hand up over here, way at the back. Somebody's blue. Oh, yes, hand.
Thank you. I want to revert back to a previous comment you made where you said if, when Canada settles with Thunderchild for the cows and plows, and then if somebody comes back and re-sues them, so I guess on the government website, there's claims that Thunderchild has submitted. There's a TLE claim, the specific claims, the agricultural benefit, and then in there it says Stony Knoll. So I'm not sure like what that Stony Knoll claim is, if it's a separate band that's claiming against Canada. So what happens if they settle a claim and then they go and sue Canada for agricultural benefits and then they win that claim? What happens with the money that Thunderchild has paid these Stony Knoll members? Will they be paying Thunderchild members back what they benefited from the Thunderchild claim? And for any other benefits that they profited from Thunderchild? That's like, what would happen then? Are they double dipping, or will they pay Thunderchild back what they've been paid from the cows and plows?
I don't think it's ever happened before, that a claim is proceeded like that. I mean, there's other examples of amalgamated nations, right, who settled claims. I'm not aware of any instance where anything like that's happened. I don't know, to answer your question.
So who would that be up to? Like if they do actually settle a specific claim and then they go and do their own cows and plows, like who would decide should they pay Thunderchild members back what they've been paid from Thunderchild claim?
And the answer again is I'm not really sure, right? Because I'm not familiar with any instance where that's ever happened, right? So each treaty signatory is entitled to the entire bundle of goods. You can sue the government of Canada for that. That's what we've done here. When the claim is resolved, that claim is concluded. Now, whether there's a future First Nation that has another claim, if they're a signatory to Treaty 6, they may have a claim. But what that actually looks like, and there's so many factors that could play into that, I just really don't have a satisfying answer for you because I have no idea really what that would look like because I've never seen it before.
Okay, thank you. Time is of the essence, and we would like to continue on with the next presentation. Thank you, Steve.
Yeah, well, and thank everybody. I really do appreciate the chance to come and provide this information. This has been a extremely hard-fought battle, so it's nice to be at this stage, and thanks again for having us up today.
Yeah, all right, since the lawyer up and, Kelly, you will do the presentation, and, this was presented in Saskatoon, and right to the point in time of the essence here. Yep. Yep. So, the presentation will proceed. You have roughly half an hour. And we have this room until 8 o'clock, I believe, 7 o'clock. An hour. Is that all?
I did. That's what I told you.
Some of that noise information was on the Thunderchild website. Notices in public places. There's also a Thunderchild app where the PCD information is on. classification information zone as well. Hello, there you go.
Good evening, everybody. My name is Kelly Christensen. I'm doing the presentation on behalf of Eleanor Thunderchild. She wasn't able to come this evening. We're just going to do a quick overview of the, it's an act respecting Thunderchild First Nations matrimonial real property. This act was actually presented, I believe it was created by Albert Angus, and Thunderchild Law has picked it up and renewed it so that it can be put forward for you to consider. The act is basically in relation to conjugal relationships and common law and married relations on the reserve. So Canada itself has a Divorce Act and a Family Law Act that governs those types of things when your relationships break down. This particular act is based on your constitution and is being put forward to reflect your needs as a First Nation. And therefore, so the Constitution of Thunderchild basically says, we the people of Thunderchild First Nation, in order to assert our inherent right to self-government and exercise.
Interrupt you for a minute. Kindly please, there's some folks here that would like to hear a little bit too much chatter here and there. If we could have more just be quiet, that's all. So the rest can hear. Right to the point.
So your Constitution reads, we the people of Thunderchild First Nation, in order to assert our inherent right to self-government, exercise self-determination, establish justice, liberty, peace, and order, create a framework of government and exercise of power, to encourage living in harmony with one another and our natural environment. So basically, this act is in relation to learning to live in harmony with each other and what happens when those relationships break down. Like I said, Canada itself has a Divorce Act and a Family Law Act that governs marriages and common law relationships. This is basically your piece of legislation that is specific to your reserve, and you get to determine sort of the terms of it based on the act, the terms and conditions in the act itself. So the purpose of the act is basically we're addressing family law property. So when those conjugal relationships break down, who has the rights to a house, basically? So if you're living in a house with somebody and there's trouble and you can't live together anymore, and there may be violence in that home, there's children in that home, basically what are we going to do in that situation? So I'm going to do a quick overview. So we're going to go through the purpose of the act. We're going to look at the occupation and possession of the family home, the death of a spouse or common law partner. We're going to talk about emergency protection orders, family violence and family violence definitions, and tribunal responsibilities. And then we'll have questions afterwards. So the purpose of the act is basically we're going to address family law property matters on First Nation reserves. So that includes occupation and possession of family homes. It also speaks to the division of interests or rights and protection of integrity of Thunderchild's territory and resources. So the whole purpose of the act is to protect the property of Thunderchild and the families that live on that property. We end up talking about the protection of women, elders, and children, and then we'll talk about to protect the community from drug dealers, sexual predators, gangs, and victims of domestic violence and suicide prevention.
Can you straighten out the screen, please? Just move the projector. Yeah. To the left. There we go. Thank you.
Okay, no problem. So, the purpose of the act also means to resolve conflicts, and the important part becomes a recognition of traditional laws. So when we talk about the occupation and possession of family homes, this applies upon the breakdown of a conjugal relationship. So an application can be made by a spouse, common law partner, or a peace officer to grant exclusive occupation. Now, exclusive occupation just basically means who gets to live in that house when the relationship breaks down. So it also applies to non-citizens, and they will have no rights or interest in the family home on the Thunderchild territories unless it's granted by a lease by council. So we're specifically dealing with Thunderchild members, and anyone who's not a non-member has to have a lease granted by the council. Occupation and possession of family homes, you have to consider the following. So the first thing any judge is going to tell you in any family law claim is that they are looking at the best interests of the child. So whether or not, one partner has done something wrong or the other partner has done something wrong, in our Canadian laws, this is sort of a carryover, that all a judge really wants to know is that the children are looked after, and the children are priority when the relationships break down. So they're also going to consider terms of any agreements between the spouses or common law partners. So if there's already an existing agreement, they'll consider those as well. And then we're going to talk about collective interests of Thunderchild citizens, customs, and traditional laws. So the Canadian government doesn't consider any of their traditional laws in their Divorce and Family Law Act. And this will allow you, as members of the Thunderchild Nation, to be able to put forth concerns about traditional laws and in relation to the customs that you hold dear. We also consider the length of the cohabitation of the spouses and of common law partners. They also take into consideration any financial or medical conditions. So if there's an issue where one partner needs to stay in the home, they'll take that into consideration as well. So occupation and possession of the family home, they must consider the availability of other suitable accommodations on Thunderchild First Nation land. So if there's the option to move for one of the partners to live somewhere else, they'll take that into consideration. Any existing orders made by the court or tribunal. So basically it's a negotiation. If you already have a court order in place, they'll take that into consideration and make sure they're abiding by that. They also consider any family violence or physical abuse, psychological abuse of any resident of the family home. Occupation and possession of the family homes must consider the following. So any exceptional circumstances, interests of elderly or persons with disabilities who reside in the home, third-party interest in the family home aside from the spouses or common law partners, and anyone who receives a copy of the application. So we also consider the occurrence of a death of a spouse or common law partner, and whether or not that impacts the Thunderchild citizens, and applies to non-citizens or non-First Nations who can apply, who can occupy the family home for 180 days after the death of their spouse or common law partners. Now, this also includes, occupation does not include custom held lands. Council has the discretion to extend the occupation beyond 180 days, and non-citizens or non-First Nations who are the primary caregivers of a child citizen may occupy the family home and custom home held land until the youngest of those children reaches the age of 18. So the only situation where a non-citizen may be able to occupy a house is if they're the primary caregiver for a child who is a citizen of Thunderchild. In relation to emergency protection orders, in the cases when family violence has occurred or a spouse is a gang member engaged in illegal activity, a 90-day interim order may be granted by the Justice of the Peace upon application of emergency interim orders. Can also provide exclusive occupation, RCMP or peace officer's authorization to evict a spouse or common law partner, or any specified person from the family home and land. The RCMP and peace officer have authorization to accompany and supervise removal of evicted persons and their belongings. In extraordinary circumstances, banishment of the applicant's spouse or common law partner from Thunderchild territories for a specific time. So, in relation to, again, we're kind of doing the comparison between Canada and Thunderchild First Nation. A lot of what Canada actually excludes is that they don't specifically deal with the problems of gang members engaged in this activity. So this is a bit stronger in language than some of the Divorce Act and Family Law Act provisions, and it allows you in the community to address those issues if they are prominent in the Thunderchild on the Thunderchild Reserve. So, in relation to emergency protection orders, any person in favor or against an emergency protection order may apply to have the order varied or revoked within 21 days from the date of receipt of the notice of the other. So you have to give notice to the other person of that emergency protection order. Anytime there is a matrimonial change in circumstances. So there's a family violence definition. Definition includes spouses or common law partners, children, or any person who habitually resides in the home. There's an intentional application of, where there's an intentional application of force, intentional or reckless act or omission that causes bodily harm or damage to property. Intentional, reckless, or threatening act, omission that causes a reasonable fear of bodily harm and damage to property. Any sexual assault, abuse, or threat, or either. Any forcible confinement. Any criminal harassment in regards to gang tourism or dealing with illicit drugs as well. So there'll be a tribunal set up, and the responsibilities of the tribunals in emergency protections are, upon the receipt of an order from the Justice of the Peace, the tribunal will review the order within 3 working days, or as soon as the tribunal's adjudication services are available, and confirm that there is sufficient evidence to support the justice of the peace making the order, and direct a rehearing of the matter by the tribunal when there is insufficient evidence to support the order by the justice of the peace. And then to give notice of the decision to the parties or person included in the order. And there has to be an approval of an order and deemed it to be the order of the tribunal. And it may vary, revoke, or extend an order within 90 days. So basically, what this amounts to is this becomes your own indication that you want a matrimonial framework to work within your specific reserve, and it's based somewhat on Canada's formulas, but it's also specifically geared towards the reserve itself and to deal with specific issues that you guys may have on the reserve that are very specific to your reserve. So that's basically the presentation. If you have any questions, you can get a hold of Eleanor, and her email is up on the screen there, or Larissa Burnoff at her email address as well. So if there's any questions, I can try and answer them.
If there's any questions, put your hand up here. We got a little bit of time left before we move on to the final presentation of the evening. And we are over here. We have a person with a hand up.
How is determined occupation in an emergency situation where it's decided? Hang on, let me reword that. In an emergency situation where one of the parents is not treaty. Now, in an example, it's a band house, treaty, non-treaty parents, and for example, the non-treaty woman has kids, and let's say one kid is the treaty, or one of the kids is from the relationship. How is it determined in a non-violent situation who would get the house? Just curious. I'm just trying to figure out how to
In a
word that.
non-violent situation?
Yeah, let's say there's a couple, they're arguing, RCMP are called, and they have to determine who keeps the house. It's a band house, he's treaty, but he's more being the problem, and she's not treaty, but she has one of 3 children that are treaty.
Right, so
Just
it's a matter of, there are several situations where they're gonna take into account different aspects of the situation. So if he has the ability to say move to his parents' house or something like that, the applicant can make an application and say, you know, he has the ability to move to a family member's house. She doesn't necessarily have the ability to move to another person's house if she's non-treaty. She would have to move off reserve, which we don't want, right? Does that make sense?
There's a million situations, and they're all complicated. I was just wondering, because I've run into situations where it was a band house, and one of the spouses is treaty from the reserve that lives in the house, and she moved in with him, and she has kids from before, but say her newest baby was from that relationship, and then he's like, no, she has to go, and then he's like, no, he has to leave.
So the
I've never
look at the best interest of those children.
Yeah, you
so
should.
the best interest of those children, whether they're biological or not, is to keep that family together. The tribunal is going to look at that and say probably in the best interest, and then find a situation where that would work for that family to either mediate or negotiate an agreement if there's not already one in place.
Okay. Thank you.
Yeah, okay, we have, it's going to be sending through some comments. You can use it.
Hello, my name is Norma Thunderchild. There were 17 tatupunan Kaya se pepe ki te e kuma. Egi peks ko e hakik. Egi tuetsik. Kini ganok. Ute kini ganok matan chiki kawapahten ki teknok tawi. Mage van wapahten tanong chini pau. Egi tuets ko te tatas tawias. Kini ganok. Ay sinuak. Kaya chay sinuak. Kawawi ko taskina. Kamaskam kuno. Pis na maki ko yaski ka na mispaino. Ais kamaskam kuno kaskia. Eguma. Kapni paus tamanuma. Ema ko imoyan. Egi pepe toke egi peks ko iba teke kuma. Niovian section o tenigane. Natansya. Kusim nog. Kitawasim snog oke. Nakigisik tamaksik. Kamantani tamanana. Kamantani tamani go te pechnawe peks ko ika teke kuma. Ego magapmutaya hanat. Muyo tayo ayaw. Itan se kung katos kata. Wag tomorrow, Thunderchild kaya, hamang sana pagita.
Thank you, Norma Thunderchild. Harrison, can you come and say in Cree what everybody has said about it? Harrison, do you have any comments in Cree? Over there, you got 2 minutes. 3 minutes. 4 minutes.
Thank you very much. Temenas mananes betama. Evani seto dapo kaya niganyo kasa niganyo. Evani niganyo teo to niganyo. And I wish we would have listened to Norma specifically what she was talking about. And those words that she spoke came as recently as the development of our election acts, our band membership acts. Those people met at the old tech. And they spoke those words. And along with those warnings, it's come true. And I too am afraid of what else they said. But the thing is, stay to it. That should be the key thing here. Respect. Let's start having respect in that. Let's hold the reserve. Put it ahead. Never mind on number one, Neil Pogorza. Even with this thing that we're going through, if you take all the money, then what in the future? Thunderchild might not exist. That reserve carries my family name, my Mushroom's name. People sitting here are related to Thunderchild. Dale over there, Walter, everybody. Wapas, Thunderchild, Okani, Kakiome Wagoftoa. And that is what this document is. It was written by a lawyer, but through the words and wisdom of one Norman Thunderchild. And he sat with a group of elders. And again, he spoke with one tongue, and that tongue was Cree, and it was filled with truth, because he spoke from the heart. Hi, it was it.
Very good, thank you. Okay, any more questions? Do you have any closing?
Yes, I'm just going to say I'm not from Thunderchild. However, I am from St. Teresa Point, which is Manitoba, and that's Treaty 5. Eleanor and I have worked together since law school, which was about 25 years ago. I have not specifically an interest in Thunderchild. However, because she's from there, she is my friend, and we're considered neighbors as treaty members. And so I would encourage you to take a look at this legislation because it's meant specifically for Indigenous people. It's not, it has legal language, however, it's including a lot of the traditional values and laws and customs of the Native people, so that you can come to that living in harmony and being able to live together in peace and order. It's meant to give you a framework to work out those disputes and be able to come to some sort of an agreement, and it's for the best interest of the children. That's always been my sort of motto. I totally support the Every Child Matters movement, and it's always, as a family law lawyer, when I deal with my clients, it's always first and foremost for the children.
Thank you very much, Kelly. Before I call on the next presenters, what we're going to do after their presentations, field a few questions, and then we'll have some closing remarks and any announcements, and then we'll have a closing prayer to close off the session. By the way, my friend over there, Mike Waka, his nickname is North Alfred. So, the Legacy Trust people, can you make your way up to the front? And we'll proceed with your presentation.
Okay, thanks everybody. So my name is Blair McCon. I'm an associate with Maurice Law. I've been working with the firm for a little over 4 years now, and I work almost exclusively on the trust funds. So basically working with the banks and then working with the council to help set up the funds that ultimately end up managing all of the compensation. So what I'm going to do is I'm going to ask Logan to put up a diagram that just kind of gives an overview of how the trust actually works. So we'll kind of explain the trust at a high level, and then what we're going to do is we're going to turn our presentation over to Megan Shannon, who is a trustee at CIBC Trust, and they're ultimately going to be the ones that are responsible for managing the money over the long term. Now, with this trust, Steve alluded to it, and throughout all of our discussions tonight, we've kind of talked about it, but the basic idea whenever we're settling any of these claims is that we want to treat the compensation as if it was the treaty right itself. So in this case, basically what Canada has said is, you know, they're not going to give any cows and cows to the First Nation, but what they are going to do is give $155.4 million. So the number one goal that we have when we're setting up these trusts is to set it up in a way that basically ensures that the compensation that the First Nation receives is completely protected, squirreled away, and invested so that it can grow over time. So the first thing to note with this trust is that when the compensation gets paid from Canada, the full amount is going to go into a locked account with CIBC Trust, and there's going to be an independent corporate trustee that's responsible for overseeing the money. What this means is that if there was ever any council, 2 terms from now or 10 terms from now, that if anybody ran for election and said, if you elect me, we're going to break into this trust and distribute out the funds, CIBC Trust's job, their number one role is to oversee the money and to make sure that that cannot happen. So in doing that, the way this trust differs from a lot of First Nation trusts that were kind of set up historically is there was always, a board of community trustees. The difference when you're dealing with a corporate trustee at one of the major Canadian banks is that they have the financial resources to basically make the First Nation whole if there ever were any losses. So for example, if you had $155 million in there, and then, in 3 years from now, somebody tried to issue a BCR, and for whatever reason, those monies were spent, CIBC has reputational risk at stake, and they have enough financial resources to actually indemnify the First Nation. So if anything happens under this trust that is not appropriate, what that having a corporate trustee will allow you to do is make sure that there are deep pockets there to indemnify the First Nation. Now, Logan, just pull it up. Can you go to so that's what I was alluding to earlier. Basically with this trust, it's designed to receive compensation from a variety of sources. So like we were talking about the $155 million on the existing trust monies, everything goes into this account and it's completely locked away and overseen by CIBC Trust. Now, when you're talking about $155 million or $180 million, what you do under this trust is you invest the full amount of the principal. So because we're talking about this large of an amount, now the First Nation is able to get access to really the best investment managers in the world. So these are the same types of people that are managing monies for university endowments, pension funds, all of that kind of stuff. The First Nation is now going to be able to access elite level investment managers. So just for easy numbers, if you have $100 million in a trust fund, and you're investing it, and you're getting the same rate of return as the Canada Pension Plan, or the University of Saskatchewan Endowment, or University of Alberta, any of those high-level institutional managers, you can basically count on getting a return anywhere from 7 to 9% over the long term. Obviously, there's going to be some years where returns are greater, there's going to be some years where it's lower, but when you look back at what a balanced investment portfolio has done basically since the 1960s, you can assume about a 7 to 9% return. So for easy numbers, we'll use 8. But if you're investing $100 million in this trust and you get an 8% return, what that means is after year 1, you're going to have $108 million. After year 2, it's going to be $116. Year 3, it's going to be $124, and so on and so forth. So, over 3 years, this trust, in theory, could grow by $24 million if you get those returns. But when you start looking at what a trust can do over 10, 25, and even 50 years, that's where you can take this initial claim settlement of $155 million. And if you're investing it and getting a decent return, 20 years from now, this trust could double, or it could be even more than that. And it does sound like a long time, but one of the things that we deal with pretty regularly as we're settling these claims is we work with a lot of First Nations that settled claims in the early 2000s. So a lot of those trusts, a First Nation would have settled a land claim in 2002 for, let's say, $20 million. And just the way those trusts are set up, that trust still might have $20 million in it, which some people say, that's great, we've protected all of our principal. But the issue is, over the last 20 years, everything else in the world has gotten more and more expensive. So if you're not investing your trust monies and keeping some in there, really the value of that money is decreasing over time. So that's the number one goal really with this trust. Like I say, it's number one, you have a trustee whose responsibility is to protect it, make sure that nobody can access it. Number two, you hire an investment manager to invest the money and get you that high level rate of return so that you can get that long-term growth, so that, like Steve was talking about, now you have that economic engine. So really what this trust is designed to do is to fulfill the same kind of function as the Cows and Plows promise, which again was to help the First Nation transition to an agricultural society. Now, obviously, it is great to say it is important to say we need to lock everything away, invest it, make sure that it grows for the benefit of the future. But we do need to be mindful of the fact that the First Nation needs financing today. So that's for everything like per capita distributions, housing, infrastructure, education, all those types of programs and services that have, historically been underfunded. The First Nation needs more money to put in, elder support, doing all of that kind of stuff. So what this trust allows you to do is you actually end up borrowing against your trust property. And this one's set at 60% loan to value. So again, for easy numbers, if you had $100 million in this trust, what that means is the First Nation would actually be able to access a loan for $60 million. Now, obviously, we're talking about 155 here. So the amount of this loan will be about $93 million. So that $93 million, that's the part that is going to be used, over the next several years to start advancing all of the priorities that the First Nation historically hasn't had enough, own source revenues to support. Now, obviously, let me talk about this too. We often get questions from First Nations about, why would we ever borrow against our monies in trust and pay interest? That's usually, that question comes on the understanding that debt is bad, but there is a difference between good and bad debt, and ultimately the distinction there is really what the rate of interest that you're paying. So when you have a trust fund that's locked away and invested by quality investment managers, and you borrow against it, all of the banks are confident with it. So First Nations, the rates that we're able to get for our clients right now are about 5%. And so the reason this model makes sense is if you're investing your full principal up here and getting 8%, and you're only borrowing 60% and you're paying 5% interest, your investment returns are outpacing the amount that you're paying on interest. So that's where we're really balancing the needs of current and future generations, right? You're getting long-term growth up here, but then you're also getting access to financing today. Now, with the loan, obviously whenever you have a loan, you need to make loan payments. So what this trust does is it sets a consistent annual payment, which is going to be 5.5% for the first 5 years, and then that's going to reduce down to 4% for future fiscal years. What that sustainable annual payment does is it really just gives the banks confidence that they're going to be able to be repaid from this. So that's again why we're able to provide, we're able to access financing at such low rates. So you know, for First Nations, it wasn't uncommon back in the day to be borrowing money at prime plus 5%, which right now would be like 12.2% would be the rate that First Nations are paying. Within this trust model, you're basically able to get it down to 5% or lower. So again, that's the whole idea behind this trust. Long-term growth for the benefit of the future, access to financing today. Now, in your information packages, you'll also see that there's a revenue account law. And so what that law is intended to do is to set the parameters around how the monies can and cannot be spent. So like I was alluding to earlier, the whole 155 million and all the existing trust monies and everything like that, it's locked away into that account, nobody gets access to it. But what we have with the proceeds of the authorized loan and the annual payment, once they end up in that account, there's a law that's going to be passed at the First Nation level that says basically what the monies can and can't be spent on. And then it also establishes an accountability framework to say that every single year this revenue account, it needs to be audited. So it would be audited at the same time that the rest of the audits are going on. There's also a requirement in there that the council put together an annual plan and budget that needs to be presented to members. So the basic idea there will be that now that the First Nation has this newfound wealth, what's going to happen is every year the administration will put together a budget that says, we're going to put $3 million towards housing, $3 million to education, $3 million to sports and rec. And they're going to present a plan to members that members are going to have an opportunity to review and ask questions with. So that's really the whole idea with these claim settlements. Like I said, is you want to make sure that you're not just doing 100% per capita distribution and dispersing the funds and having them spent in North Battleford or Edmonton or Saskatoon. What this model allows you to do is completely lock away everything so that it's there for the benefit of the future. And then basically you're living off the interest. So another way of thinking about it is like the goose that lays the golden eggs. The trust itself is like the golden goose. You want to protect it and grow it. And then you just want to live off the revenues, which in this case is the authorized loan and the annual payment. So within this model, I am happy to take any questions on it, but I do think it would be helpful to turn it over to CIBC Trust. With Marie's law, we structured this trust, but we're not the trustee, we're not involved in this over the long term, so we don't have any interest in setting it up this way, other than we think this is the best model. And what ends up happening now is we turn it over to the trustee, and now the nation will have a relationship with CIBC Trust, and they're going to be the one that's responsible for overseeing the fund, helping select investment managers, and then they're going to be the ones that are involved in the day-to-day, really, administration of the trust. So I'll wait around for any questions, but until then I'm going to turn it over to Megan Shannon from CIBC Trust, and I'll give her an opportunity to basically present on their role with regard to this trust.
Yep.
Yeah. Sorry, Megan. Yeah. Just a question.
Hi, so you said that we could invest 93 million. That's 93 million, not including the debt from our old trust, right?
No, so you're investing the whole 155, and the entire existing trust monies. So everything, going back to that diagram, everything is going to be invested in that larger pool, and then you borrow against it. So you can borrow 60% loan to value. So whatever is the amount of that trust up there, you can always get a loan that's up to 60% of that.
So essentially a loan to pay off our old debts.
Yeah, like the existing debts that are there, it's basically 50% loan to value. So it's basically going to be the same. So it's just going to be, all the existing debts are going to be like wrapped up within this authorized loan, but then everything's going to be governed by this agreement.
How much is the debt?
Can we have a mic in the back here?
Yeah, hang on, here's a question being asked over here.
Yes, sir. How much is it? How much is the debt that's going to be incurred in that?
I don't have the exact numbers, but I think last time I checked it was 20 million. So
20 million?
If you have a $40 million trust, it was like 50% loan to value. So it's basically a similar model to this. And then the other thing I can say about this is, you know, this is kind of a unique model that's just coming to First Nations. But like I say, with university endowments, this is basically the exact same way they're set up. So when, you know, a university has rich benefactors that somebody went to the university and then they donate a bunch of money to build, you know, a medical center or whatever it is, this is basically the same model that a university would use. They take the money, they invest it, and then they borrow against it to basically create a mortgage for all of their, you know, their capital costs for new medical buildings. So that's basically the same type of model. And the reason we use this is because, like a university, First Nations are going to go on in perpetuity. You know, it's not like, you know, an individual who's going to retire in 10 years that, you know, they have different investment horizons. When you look at that long-term growth, that's really where you see this model. So it's based on all these same types of structures as, you know, other institutional type investment funds.
Okay, the next question is coming from over here. Do you see me over here?
Yep. Nigan wahumagan tikto tentik kematam sa nawaw. Kiwe ino datuma, which kind of relates to why we have CIBC here. I don't know. As some of you are aware, at one point in time I was the chief for Thunderchild. And I hear from my daughters from Saskatoon meeting yesterday, I'm still being accused of stealing Mama Scotch. And I think at some point I have to take some legal action here because I shouldn't be. Why am I 13 years later, why am I still being accused of stealing band funds? But you know, to me, the real culprit is CIBC. And the story I want to relate to you is when I first got in as chief, the band was in dire straits. Who was our banker? Guess who? CIBC. There also, and the first question I'm going to ask this gentleman here is, has CIBC ever been the corporate trustee for any of Thunderchild Trust money?
I understand that CIBC was involved in one of the business.
Yes, just answer yes or no.
Yes.
Yes, they were. As chief, one of the first things I did was I fired you and I was going to sue you. Why?
To be clear, I work for Maurice Law, not CIBC Trust, so I'm not too sure on that.
So this is for CIBC. Why did I fire them? Why did our council decide to fire them? And Mel can talk to this, Jerry was band manager at the time, they can attest to all of this I'm speaking about. Was as a corporate trustee to CIBC, they spent millions of dollars on the 1908 trust money, Specific Claims Trust, TLE Trust. When I got into office, there were no minutes held by the corporate trustee for any of those millions of dollars of expenditures that took over those years. Not one single minute to account for that expenditure. And it's sure enough easy for some people to stand up and say, point fingers at past leadership and say they did it. When the corporate trustee didn't have 1 minute account, which they were legally responsible for as the corporate trustee. So my question to council, my question to people here is, why is CIBC being our corporate trustee when they have not proven they could do that for us? That's my question. How can I trust you? How can I trust CIBC? Maurice Law, have you had a in-depth look at our internal laws? Any of our laws that ever been challenged and taken to federal court, the federal court says take it back to the tribunal because Thunderchild, you have your own legal court process in place. Why are we setting up these other mechanisms when we have an internal process? I have been involved in 3 cows and plows for Alberta bands where I was the translator and worked with the lawyers. And through that process, I did not come to a place where if a band, the offer was made, the offer was accepted. Now it's up to the membership to decide. And what the membership I'm hearing is saying, and what I'm here to say is, yes, we accept the offer. But no, there has not been enough consultation. There hasn't proper mechanisms in place, utilizing our own internal legal processes to do any of this. Even this matrimonial property, it's a great idea. And I'm sure a lot of that is great. But we have not had the opportunity to properly look over it, discuss it, review it, and make some sound decisions based on that. So if the question, if I still want to see what the questions look like. But those are some of the things I want to throw out there. And the other thing CIBC did, folks, is when Winston Weekes, late Winston Weekes, he was the chief, elected as the chief at the time. In 2007, when he stepped into that office, he seen the financial mess Thunderchild was in. We were bleeding. Our POs were not accepted anywhere. We had no money. And one of the biggest reasons, when I hit the office, took over office, the first thing our council had to deal with was that situation. And what caused that situation? One of the reasons being CIBC, who was our banker. CIBC called in all their line of credit that the band owned, which they were maxed out. Public Works was maxed out. The band operations was maxed out. Jerry. They were all maxed out because CIBC took the money, leaving the band with nothing, absolutely nothing to work with. That's what I stepped into. That's what my council of the day stepped into.
Sue them!
Yeah. That was the plan. That was the plan. But I never spoke to anyone about this situation. We just said, okay, boys, we've got a job to do. It's a tough one. We've got nothing to work with. We started from there. And CIBC, instead of turning our back, turned on us. Why are you here? I don't know.
Thank you for those comments. Any additional comments, questions? For the time is up on the floor. Any hands up over here? Do you have any closing comments?
Who's gonna answer that question? Why are we using CIBC again then?
Nobody's answering.
Yeah, so what I can say is, obviously, we weren't involved in 2007, but we did go through an RFP process when we were looking at this trust in order to say, we looked at all different types of things, everything from, the trustee services, the rates on the authorized loan. And one of the critical factors was that CIBC was able to offer the lowest rate on the actual loan. So that was one of the deciding factors in there is, there's a difference between paying prime minus half and paying prime plus half. If you're talking about a 1% difference on a $90 million loan, that's $900,000 a year. So that is that's one of the deciding factors is rates on the authorized loan. That's one of the biggest things that we look at. And then I guess the other thing that I will say within these trust models is that I can't speak specifically to what happened within the early 2000s, but the whole idea with having a corporate trustee and no board of community trustees is that if there ever is anything that goes wrong and like money's ever disappeared, you can sue the bank. That is the exact reason why it's set up that way. You can't get blood from a stone, so when you're dealing with individuals, if you have a board of 5 community trustees, nobody has more than $30,000 in their bank account. If $5 million gets misappropriated, you can't ever get that money back. If any money disappears from a trust account that is overseen completely by an independent corporate trustee, CIBC has billions and billions of dollars to indemnify the First Nations. So that's why this model is being used now, is because for exactly those concerns, if there ever is anything that goes wrong, they're the ones with the deep pockets that can indemnify the First Nations.
Okay, so but as you stated, you're an employee of Maurice Law. That should have come from the CIBC trustee representative. And like you said, you don't know the history of what happened in the early 2000s, so maybe somebody that is more informed about our history could speak to why we're going with this bank then?
Yeah, and I guess maybe I can just clarify, because Maurice Law was involved in the RFP process, as Steve was saying, we represent dozens of First Nations across Treaty 6. And frankly, one of the things that we're dealing with generally with all of these claim settlements is that there's all kinds of people that are coming out of the woodwork that are trying to get First Nations to invest their money with them and do all of that kind of stuff. So as the First Nations Legal Council, we like to help First Nations, guide First Nations through that process in terms of appointing good investment managers, appointing corporate trustees. So that's why we represented the First Nation on this actual RFP. We submitted requests to, it was TD, CIBC, Scotia, there was multiple banks, and we compared terms from all of them. And what I can say is their legal counsels, when we did the apples to apples comparison, they had the lowest rate for the First Nation. That's going to result.
Okay, having said all that again, still, my question's not answered. Who made that decision to go with CIBC, and who can speak to that here?
It's ultimately a decision of the council.
Okay, well, are you speaking on behalf of the council?
No, but there was a BCR signed by the council appointing CIBC as trustee.
Okay, but why? Why would we go with them if we've had this bad history, as our past chief has said? Why would we? Can nobody answer that? Why we're going with CIBC?
I think I can.
If this happened before?
I believe the reason why they're going with CIBC as an outsider looking in and coming into the situation wave on the back foot. What they're saying is CIBC is going to give us the best deal. They're not looking at the past, as looking at CIBC as a villain and an entity that's out to get us. Which they probably should. Because CIBC, ripping us a new one or an old one, 2003.
So why are we going to give them that opportunity to do it again?
Because they're giving us the best deal. And from the way that Chief and Council has set it up, the trust that's being set up, it's being looked at by a third party.
Who gave
And if
Chief and Council that
CIBC,
power?
if CIBC
Who
takes
gave them
anything
that
and does anything
power?
wrong,
Who gave them that power though?
We did when we
What if
voted
they
for
don't
them.
speak on our behalf?
we did when we voted for them.
Wait, who voted for them?
I did.
Because I didn't vote for them.
Chief
I didn't
Council.
vote for Delbert.
We
I
voted
didn't
for
vote
Chief
for
of
Delbert
Council.
either.
Chief of
It
Council
doesn't speak
took
for
that
me.
authority that we gave them, and they made the decision to go with a questionable bank. And we're gonna have to ride
Who
along
will
with
be
it.
held accountable when things go sideways? Who will be held accountable?
Okay, we're on the floor, please. One person speak at a time. Are you done over there?
We wanna know who's gonna be held
Okay,
accountable.
finish what you have to say. Finish what you have to say.
Well, pretty much finished. I'm right there with you, wondering why we're going with a bank that ripped this one, 13 years ago. Is that 13 years ago? 13 years ago, we got ripped one by a bank. Now, we got a big bunch of money coming in from the government. We wanna know where to put it. And he just told you 1% is a lot of money. 1% is $900,000, is that right?
On a $90 million loan.
Yes, $90 million loan, 1% is $900,000. Most I've ever seen in my life is $20,000 when I got a loan 3 years ago. 900,000 is a lot of money for our people. So the people that we elected, these guys, they took the authority that we gave them and they said, okay, we're gonna give this bank another chance because 900,000 is a lot of money. Am I correct?
Yeah, and just to be clear, that's 900,000 every year.
That's pretty cool.
I also want to
Okay, let us, respond to that. Councillor, Melvin Thunderchild has the mic and will proceed with what he has to say with his comments.
Naskamun Kitam Etawaguta Kapixquake, Aganistanan, Kau Kapixqa. I want to thank Dale for the question there, Dale. I served under him 2007, 2010 as deputy chief. At the time, and Dale is telling the truth. He is telling the truth that we were in bad shape at that time. When we came on, that pretty much CIBC shut us down. You know, after we decided to fire him as our corporate trustee with our SLC claim, or SLC trust. So fast forward now, you know, why would I select CIBC? It was hard. And council, our engineer, they heard me. I brought that issue up, Dale. I did. I brought that issue up. I had another bank in mind, but again, you know how it is. It takes a quorum. It takes a quorum to make decisions in leadership around the table. I spoke what happened back in the day where CIBC did not do the job they were asked to do for Thunderchild First Nation. Again, fast forward to now. You know, you heard Blair here explain there was a process where we had to select an institution with our trust today. And there was 3 banks that responded with that RFP, Scotiabank, a credit union, and CIBC. I was pulling for Scotiabank, but I got outvoted. But again, you know, that's why CIBC is here today. You know, they assured none of that will happen again. That happened 13 years ago or whenever it happened. Today is a different story. They told us, you know, I was vocal, you know, what had happened in the past. This is not the first time CIBC was selected to be our corporate trustee. The first experience didn't go well. This time, for sure, I don't want this to happen again, and they assured us. So with that, you know, again, I hope that explanation helps. That's why CIBC is our corporate trustee today. Thank you.
Thank you, Mr. Melvin, Thunderchild. How are we doing for time? We could do a couple more questions. Oh, we have the back over here.
So, I want to say, first of all, what Dale was saying about the vote that we are all going to be taking place, that's going to be taking place here, and one in Thunderchild tomorrow, and one that's been done already. So I think this is where I think there's a lot of confusion and a lot of anger and a lot of, we really don't know what's happening and how things how we've come to this point here. And like Dale, I want to take the $150 million. I want to. I want that money to go to the people. I want the people to have a say in how that money is being spent and where that money is going. And I think I also need to say to Aaron, yes, we have elected officials here. There's no question about that. But Chief and Council do not have absolute power over the people of Thunderchild. We have legislation, we have laws that the Chief and Council are supposed to follow. And within those laws include having the people of Thunderchild have a say. And that's all it really boils down to. All of these issues, and I'm sure over the years, I have them, thank you, Corey. Over these years, you've seen me, myself, you might have seen the same people asking the same questions about the trust, constantly bringing up our Constitution and our laws. We are asserting our rights for self-government. I'm not here to try and get people upset or try and create division. I'm asking questions, which every other band member has a right to ask. I have grandchildren who are going to be affected by this. I'm not saying, no, I don't want the $150 million. I'm saying, I want the people of Thunderchild to have an actual say in what's going on. And have a say in where this money is going and how much each person should get and what investments are being taken place, because we have absolutely no idea what investments our bank has been investing in. And I'm hearing we're in debt well over 50 million, 60 million.
Debt.
How did that happen? And why do these people have to pay it back? Why do they have to pay back bad investments?
Right.
Yes, I want what's best for the people of Thunderchild. But we shouldn't have to be manipulated to vote just to fill other people's pockets. Thank you.
Right on.
All right, my name's Aaron. I was called out by name, so I'd like to respond quickly. From what I've seen, what I heard, and what I've has been confirmed by lawyers, which is a pretty big deal. Thunderchild's not paying anything back. Thunderchild's not paying 1 cent back, not one bit. This $155 million is going into a questionable bank trust. We're going to have to trust CIBC. None of that money is going to anywhere else but in that trust. The only money that we're going to be able to spend from that trust is 6%. And already, most of that 6% is gone. And if I'm not correct, if I'm correct, is 6% of 155 $9 million? Come on, lawyers. You guys got minds. Where's your calculators? Yes. Chief and counsel. Yes, $9 million, 6%. So that's $9 million a year. Out of that $9 million, that's where we're going to be able to spend money. That's where we're going to be able to watch chief and counsel spend that money. That's where it's going to be hopefully transparent. But not too transparent, because we got to give them a little bit of trust because we elected them. They promised us. My brother promised me. My bro promised me. My uncle promised me. He made promises to me. If I vote for him, he's going to take care of us. So, I found out I was going to get $45,000. Like, yeah, $50,000, yeah, all right. And half of it. Oh no, we're going to keep half. No! That's mine, and I lived off of res all my life. You never helped me. No! These are my feelings. So, I came here with these feelings bubbling over, mad as hell that chief and counsel that never helped me for the past 33 years, never one little cent to help, no matter what I asked for. No, you live off of res. I was mad. They're going to take half of my money. I found out that I had my chance to tell them what I wanted them to do with that money, how much of that money I wanted. I found out that I kind of got it was a little sneaky. I only had one chance to tell them what I wanted. 1,100 of us showed up at that meeting. Guess how many people told them a number and how much what actually did what we were there for? 11 people spoke on our behalf. 11 of us, not chief of council. 11 of us said, "This is what we want with our money." And chief of council looked at it and said, "This is unattainable." The government said no, because 9 of them said 100%. And the government said, "No, you guys want 100% distributed to your people?" That wasn't am I correct? Lawyers? The government said absolutely not. Lawyers said it, I believe them. They get paid to be honest with us. We pay them to lie to other people.
That wasn't a vote.
It's true.
That wasn't a vote.
I know a little bit of something about corporate autocracy. Corporate stuff. All that, a little bit, not enough to actually stand here and teach you guys anything, but enough to trust these guys a bit. So the message is simple. We had our chance on October 27th or September 27th. When was it? When was the meeting? September 18th. That was it. That was our chance. 11 people got up there and they let their emotions out like I'm doing now. Took up a lot of time. We were supposed to go one by one, 1,100 people online, and the 700 online and the 400 in person. We're supposed to go one by one and say, I want 90%, I want 50%, I want 80%, I want 100%. But only 11 people spoke up. So chief of council said, all right, we get to do what we want because we didn't get any info. So it was on us.
When was that
and it was
meeting?
on us on these people. Hold on, wait, you can have this.
Yeah. When was that meeting though?
You got told.
I just told you.
Could you get to the point?
The point is, sorry, we're over our time. Okay.
There was no vote.
There was no vote. It was our time to tell them. They would have tallied up and would have taken the most amount of
There was
numbers.
a vote.
There was no vote.
There was no vote.
There wasn't a vote per se, but they would have taken each person's.
Okay, let's get to the point.
You weren't even there.
I was online. I was one of the 700.
Majority of everybody said we wanted a full payout, or at least 80% of it. I was there. I spoke at Thunderchild meeting.
Yeah, 11 people
I was
spoke.
at the meeting yesterday in Saskatoon as well.
That was our only chance of the day.
Majority
No,
of us
it
said
wasn't. No, it wasn't. That was supposed to be an informational meeting. They didn't give us any information. That's when we should have got this package at that meeting and said, okay, this is what we're doing. What do you guys think? That's how it should have went. I appreciate your opinion though, sir.
Okay, thank you. Francis, Jimmy, where are you? I've run out. We went over time, a lot of good questions. Answers were derived at,
Let's
are
go
you going to
home
a parade over there or over here? Okay, the parade is on.